Welcome back to the Self-Represented Litigants Society's legal terms that begin with the letter F. I want to remind you that we have further volumes coming soon, and we will be publishing a PDF version of all of the legal terms found in the whole alphabet once we are complete with this video series on the YouTube channel. So stay tuned for that. A factum is a document in a court case in which a party sets out a concise argument stating the facts and laws relied on. Typically, this will be accompanied by an application record, or a motion record, or a trial record. So it is a supplementary, let's say supplementary, document that will accompany the physical evidence that a party wishes to rely on. And this is typically the bulk of the arguments that will be made in oral form at the trial or the hearing. Stay tuned to the YouTube channel and to irepmyself.com, where you can become a free website member and get lots of great free behind-the-scenes information, including a how to create a factum video coming soon. False pretense is a representation of a matter or fact, whether present or past, made by words or otherwise, that is known by the person who makes it to be false, and that is made with a fraudulent intent to induce the person to whom it is made to act on it. Now, I would point your attention to the Criminal Code under Section 361, Sub 1, where false pretense in itself is not a criminal offense. But when combined with another action or omission, that's when you can get a criminal charge. For instance, false pretense or false statement. So everyone who commits an offense by false pretense, whether directly or through the medium of a contract obtained by a false pretense. So as you can see, this is under 362 now of the Criminal Code. False pretense in itself is not a criminal code offense in Canada, but making or portraying false pretenses in the pairing of another action is typically a criminal offense. A fee waiver is a mechanism for waiving court or enforcement fees. People who cannot afford to pay may request that these fees be waived. Fee waiver applies to most fees in civil, family, and small claims court proceedings. It's good to note that they don't apply to court costs. So if court costs are ordered against you, you can't have a fee waiver against that, obviously. A request form must be signed and submitted, and a determination is based on financial eligibility criteria. Typically, the form that you submit to the clerk at the courthouse will be an affidavit, so you'll have to swear or basically promise to tell the truth in that your financial circumstances are a certain way. In Ontario, if you are on the social assistance program in Ontario, so disability or Ontario Works, then that means that you're automatically eligible for a fee waiver. Fees are a charge for services. Most notably, contingency fees are fees payable to a lawyer only if a case is successful. They are usually based on a percentage of the client's recovery. Typically in Canada, you'll see that somewhere around 30 to 40%. And in addition to the recovery in a percentage form, a lawyer can also recover out of that contingency fee their disbursements, which are separate and aside from the recovery or the percentage that they'll get from the award or the settlement. Fiduciary is a person who has a legal obligation to act in good faith for the benefit of another person. For example, a trustee. It describes the nature of the duty that such a person owes to the beneficiary. So, for instance, you'll hear fiduciary duty a lot in the legal system, and a fiduciary duty means that somebody has a duty to act in a certain way, usually, obviously, in good faith. Foreseeability is a concept used in various areas of the law to limit the liability of a party for the consequences that are within the scope of a foreseeable risk. So what's that mean? Well, first of all, this can be in the context of a criminal matter, or it could be in the context of a civil matter. And foreseeability is essentially the ability, or what a reasonable person may hold to be the ability to foresee something, or to think about the possible outcome of something ahead of time. So, for instance, if you're talking about negligence, usually the effects of a person's acts must have been foreseeable for negligence to be applicable. And in the criminal context, for instance, in assault, in simple assault, you can have an assault take place and it not be a criminal charge because it wasn't foreseeable that contact would be made. For instance, if you're just walking down a hallway and accidentally bump shoulders with somebody, that person who got bumped might say, "Oh, that was assault," and ask the police to lay a charge. But on the other hand, the person that was walking down the hall, if they couldn't foresee what was going to happen and it was an accident, it was truly an accident, then obviously there's no assault that has taken place. Forthwith means immediately or within a reasonable amount of time under the circumstances. It's good to look at R versus Grant, 1991, Supreme Court of Canada. So in this case, the accused was charged, I believe, with impaired driving. I'll leave it to you to take a look at the case. But essentially, it deals with forthwith being the term used in the criminal code at the time, I believe. There was an issue as to how fast the police officers brought the testing device to where the person was being detained. Again, R versus Grant, 1991, Supreme Court of Canada. Frustration is the inability to complete or discharge a contract because of circumstances beyond the control of the contracting parties and outside their contemplation when making the agreement. A fugitive is one who flees from justice. Take a look at the Extradition Act for more. Or take a look at the Harrison Ford version of the Fugitive the movie for an awesome movie. The fundamental principles of justice, or the principles of fundamental justice, are the fairness underlying the administration of justice and its operation. The principles of fundamental justice are specific legal principles that command significant societal consensus as fundamental to the way in which the legal system ought fairly to operate. See Section 7 of the Canadian Charter of Rights and Freedoms for more information about some legal rights. Section 7 actually lists and refers to the fundamental principles of justice. And it doesn't go as far as some people would hope the Charter would. But essentially, the fundamental principles of justice can be found in common law and in case law as being very well defined. An example of a fundamental principle of justice would be that the court system is based on the premise that if you are named as a party in a lawsuit, then you deserve to be notified of that. And there has to be, quote unquote, proper service of this notification. So that is just one of many fundamental principles of justice. And thank you for watching. Again, subscribe to this channel, like this video, and please share it. Come back for more, and stay tuned as we present a PDF version of all of the video series that we are completing on this topic. That will be available on our website, irepmyself.com. Make sure you become a free website member to get our newsletter to find out when that will be.